Abby?
Yes,
Hi, what case are you here on?
I'm here on two cases, Ally versus Eva Sims and Focus Hope versus Willie Cross.
Do you have case? Oh, okay, I see you. So who are you here in place of? Terry Grucha?
Yeah, Shermetta Law Group. It may have been Terry Gruca as the attorney record.
And then Allie, okay. Allie Financial versus Eva Sims?
Yes, yep.
All right. All right, I'm going to put you back in the waiting room until we're ready for you, okay?
Okay.
on the Galaxy.
Hello,
Hi, what is your name, please?
this is Willie Cross.
Willie Cross. All right, I'm going to put you back in the waiting room. I just needed to make sure who you were, okay? We'll be with you in
All right.
just a few minutes. Judge, we have some people.
Good morning. Are we ready on Focus Hope versus Cross?
Your Honor, John Avancher on behalf of the defendant, if you could put me and opposing counsel in a breakout room, be greatly appreciated.
Sure.
Thank you.
Heather, you got that?
Yep.
All right, appearances on Focus Hope versus Cross again.
Yes, good morning, Your Honor. Abby Gadowski, Demeray, P81966 on behalf of plaintiff.
John Ivanchik on behalf of defendant, Your Honor.
Are we ready?
Your Honor, instead of going forward with the motion, counsel and I have spoken, and if we could, we'd like a short adjournment of the motion. Hopefully the next nearest available date, if possible, like a week or two, if possible, with the court schedule. We should be able to resolve it without the need of the hearing, but just to provide some finality to it.
All right. How about Tuesday, the 26th at 2?
That works. Let me double check my calendar. That should work. Yeah, that works for me.
Works for me as well, Your Honor.
All right. I'm squeezing you in, so if you resolve it without me, let me know.
Okay. Thank you, Your Honor.
Thank you, Your
Heather,
Honor.
you got that?
I do, Judge. Thank you.
Thank you. Have a good day, folks.
Thank you, Your Honor.
Hi, Attorney Francis.
Good morning.
Good morning. What case are you here on, please?
I'm here for Bank of America versus James Moore
So you're here for Mr. Oldcheese?
from Weber and Olsey's office. Yes.
All right. All right, I'm going to put you back in the waiting room till we're ready for you, okay?
Okay. Thank you.
Thank you. On the iPhone, what is your name, please?
Jessica Harris.
What case are you here on?
It is for an eviction notice of here. Notice of here. For hold on. Yeah, for Metro Commons.
And it has today's date.
Yes, but it's not until 1:30. I just never used Zoom before, so I just
Oh,
logged in.
okay. If you can, that's fine. If you can come back at 1:30.
Okay.
And when you come in, it should ask for, you're able to name your phone. If you can just put your name on there and maybe the case number.
Okay. Okay.
Just as long as we have your name, we're good, okay?
Okay. Thank you.
Thank you. We'll see you then.
Okay. Bye bye.
councils, while we're waiting, did you need to speak to each other in a breakout room? On the Sims case?
We can.
All right, I'll put you in a breakout room.
I'm not sure what happened, but I didn't go in.
I'm not either. Did it give you something to request the room?
I think I'm on a browser. It timed out, so that may have caused an issue.
But it doesn't, there's not a spot for that's asking you to join the room?
But there was.
And now it's gone.
And it didn't go through.
Okay, I'm gonna try another room.
Okay.
I wound up being the only person in there.
I know, and I just moved you to another room. Let me close these.
Oh, sorry.
No. She said she thinks something was wrong with her browser, but I don't know that that should have messed with anything.
Yeah, I don't think so. Oh, now we're both back.
Okay, good. And now I'll put you back.
All right, we're all set. We're ready to go.
All right, I'll let the judge know.
Thank you.
Appearances on Alley Financial versus Sims, please.
Good morning, Your Honor. Abby Godowski, Demaray, P81966 on behalf of plaintiff.
Good morning, Grant Munson, P71994 for defendant.
Good morning. So pre-trial, what do you guys need from me?
Your Honor, at this point, oh, sorry.
No, you go ahead.
Okay. Your Honor, at this point, I think we're just looking for 60 days discovery. I think we'll probably work it out one way or the other before the next time we're here.
All right, 60 days written discovery, I assume?
Yeah, I don't need any depths.
We'll just adjourn the pretrial after that?
That works for me.
Yep.
All righty, look for your notice. We'll send out a computer-generated notice.
All right, thank you, Your Honor. Have a nice day.
All right,
Thank you, Your Honor.
Judge, next is Public Service versus Frank Williams. Frank Williams is
Thanks.
not in the waiting room.
Thank you. Counsel, your appearance for public service, please.
Good morning, Your Honor. Maljean Castillo Shoemake, key 62247 on behalf of Public Service Credit Union.
And this is a show cause because Mr. Williams did not appear for a creditor's exam, correct?
Correct, Your Honor. He was personally served on August 16th for the subpoena. And he was served by first class mail pursuant to the show cause order on September
Thank you.
2nd.
And what's your judgment balance outstanding?
The current balance, Your Honor, is $18,370.63.
Let's see if a $3,000 bench warrant gets his attention.
Would you like us to
You prepare the paperwork?
Yes, Your
Yep,
Honor.
prepare it, send it in. You can do it by email, I believe, if you send it to Civil.
Oh, okay. What would be the email address, Your Honor?
That would have to come from Civil. So
Civil,
watch your
okay.
chat. Sandy will send it to you.
Okay, thank you.
I can't hardly remember my own, so I can't remember theirs.
Thank you, Your
Have a good
Honor.
day.
Judge, next I'm going to bring in Rourke and DePietro for the Moore versus Moore and Moore.
Yep. All right, good morning, attorney types, your appearances.
On Ruark, Your Honor, for the plaintiff.
Good morning, Judge. Tom DiPietro appearing on behalf of the Moores.
Thank you. Good morning, Mr. and Mrs. Moore. Gentlemen, have we got any resolution from the probate court yet?
We do, Your Honor. I just sent it over to the court about 15 minutes ago. Judge Braxton ruled in my client's favor in favor of the trust. I do not believe, and Tom can correct me if I'm wrong, I do not believe there's been an appeal. And I believe that the appeal period has run. And so the trust is, I mean, Glenda Moore is the rightful trustee of the trust.
Judge, excuse me, I was putting my headphones on and didn't hear what Mr. Work addressed to me.
Tom, I simply said that the Judge Braxton had ruled in favor of Glenda Moore, that she is the rightful trustee of the trust. That decision, I think, was dated at the end of August. I do not believe that there has been an appeal. And so Glenda Moore is the legal trustee of the trust.
May I respond, Your Honor?
Mr. DiPietro, agree?
I agree that she's the trustee.
Okay. So where's that leave us with my file?
All right. We don't have the real party in interest before, Your Honor. There was no suggestion of death filed in this case, but I do stipulate that Mr. Moore is deceased. I don't remember the date. The real party in interest is Kevin Moore. He is the beneficiary under the trust and the person who is entitled to possession. The trustee is not entitled to possession because the trustee was never in possession. All during the pendency of this matter, my client has been in possession. So the trustee owns the legal title, but the equitable title lies in Kevin Moore. It's his property. And it seems to me that in order to make a final disposition of all persons interested in this case, that we need Kevin Moore in here because he's entitled to possession if anyone is, not the trustee. So it's more of a question in my mind of possession rights than it is legal rights, because the only power the trustee has now is to deed to Kevin. And he's not here.
All right,
And I think he
hold
should
that.
be, Judge.
Hold that thought, gentlemen. Hold that thought. What do you got? Mhm.
So whenever you want to squeeze it in,
Okay.
just let me know and I'll call
Awesome. Beautiful. Thank you. Okay. I'm sorry, Mr. DePietro, were you done?
Yes, I was, Your Honor. Thank you.
Okay.
Your
Mrs.
Honor,
Moore,
if I
would
may
you like to
respond to that. Mr. DePietro is correct in that the property is going to be ultimately deeded to Kevin. Kevin and the trustee, and I'd be glad to deed it to Kevin today if Kevin wants it today. Kevin, I believe, wants this eviction proceeding completed, and then we're going to deed it to Kevin as soon as Kevin says, I'll take the property now. But right now, the trust is in complete control of the property, at least in complete legal control of the property, and the trust is the owner of the property, and Glenda Moore represents a trust that's all been settled in court. And I think that Mr. DePietro's argument is somewhat specious if he says the owner of the property cannot proceed on the eviction. There's been no deed yet to Kevin Moore.
He's a person entitled to possession, Judge. That's the bottom line. He's not in his courtroom. We're told that he doesn't need to be here. We're told he wants to be this matter to move forward. His rights are paramount to the trustees' rights because all the trustees doing is holding a deed. And they have an absolute duty to deliver that deed to Mr. Moore because he has all the possessory rights. He has, if you want to put it in a percentage, 99% of the ownership interest in this property as the equitable title holder.
And right now, the only title holder is the trust.
Anybody have any law?
Well, the law for me is very clear. The trust owns the property. The trust is entitled to possession of the property. Okay. Kevin Moore eventually will get the property. Once the eviction is over, we can deed it over to him. But right now, the trust is the owner of this property. That has been settled, and this is nothing more than a further attempt to stall. Now, if indeed, the Moores, Lisa and Eric need more time to move out, we can work that out. But this argument, it makes no sense. If he's got some legal authority, I'll be very happy to look at it. But the trust owns this property and has the right to proceed in this eviction.
Your Honor, this does not address the question of who's entitled to possession. The trustee never had possession. The trustee can't convey possession. The trustee is attempting to obtain possession, but there's another party out there who has a greater right to possession than the trustee. Now, we can sit here and say the trustee's going to do this and the trustee's going to do that, but there's no compunction to do that without some participation from the guy who owns it. I mean,
the trust owns it.
It's an equitable title
Hold
that
on.
Kevin has.
Let me change the analogy, Mr. DePietro. If I buy a house, but I never live in the house and I put a tenant in it, your argument would say that I have no right to evict that tenant.
Negative.
Because I've never lived in the house.
The statute gives you the right. The statute gives the right to the owner to remove the tenant that you put into the house. This is not that case.
Why wouldn't the trust be in that same situation?
Trust never had possession. The trust did not give.
The trust, hold on. The trust had as much possession in the case scenario as I had in my analogy. I was the title holder, moved a tenant in. The trust has been the owner of that property for years, my understanding is. Now it's a different trustee in charge of the trust, correct?
Yes, Your Honor.
Correct.
You conveyed possession to your tenant. This trust conveyed nothing to this tenant.
It became trust property after Eric Moore moved in?
Oh, yes, Your Honor. Eric's been in 30 years.
No, Your Honor, Eric has lived there 30 years. That's uncontested, okay? The trust has owned that property from the very beginning. The Court of Appeals clarified that. Now, Eric may not have recognized the ownership of the trust. He fought it tooth and nail, but the trust has owned that property since 91 or so, 90 or 91, when it was purchased by the trust.
All right, I didn't catch what you just said. The trust has owned it since 90 or 91 when, and I didn't hear the rest.
When James Moore, the trustee of the trust, purchased it. So if he didn't own it in 91, he certainly owned it whenever he put it into the trust. I believe he purchased it from the trust, as I recall. And that's been settled. And Glenda's right here with me, by the way. She's indicating something else. But at some point, the property was put into the trust. And it's been settled that the trust owns it. That is a legal fact in Michigan.
I stipulate they own.
They went into the trust in September 96.
I think the point Mr. DePietro made was that Eric was in possession before any trust owned the property. Did I misunderstand that argument, Mr. DePietro?
No, Your Honor.
Okay. That is correct. The trust did not own the property until September of 1996. The Court of Appeals has affirmed the ownership of the trust.
Agreed.
Okay, but
then the trust can dispose of the property the way it wants to.
But Eric had possession before 96, correct?
Yes, he's had possession since I think around 91 or so. Okay. 1990.
And my question back to Mr. DePietro is, do you have any law? I mean, this is an interesting argument, Mr. DePietro, I'll give you that, but do you have any law that says because Mr. Eric Moore has been in possession longer than the trust has owned it, that the trust does not have a legal right to evict him?
No, and I don't contend it. What I contend is you need all real parties in interest before that move is made, because the trust's interest is de minimis. It does not have a possessory right. It never had one. You can argue that it should come attendant to legal title, which in most cases is a fact. But the two, during the life of this case, never merged, and upon the death of Mr. Moore Sr., Kevin became the owner. All he needs is a deed. This guy's got 99 of the 100 sticks, and he's not here. That's my contention.
When he gets a deed, he'll be the owner. Until then, the trust owns the property. That's a legal fact. That's just the way that it is. It's been established by the Court of Appeals. It's been established by the probate petition. That's all been in favor of Glenda Moore as the trustee of the trust. The trust owns the property right now. The trust will convey the property when it does to Kevin Moore, and then he will own the property.
Judge, the issue of possession has never been touched on by a court. You're the only court that has before it at any time the question of possession.
And the trust has the right to possession, as is put in the complaint.
I frankly don't see the harm in allowing a guy who's got 99% ownership being in front of this court and being bound by this court's decision, or having the opportunity to be heard by this court.
He has no interest right now in this case. If the trust at a future date does not convey the property to him, he will have an interest in suing the trust, but not in this case today. He has no interest whatsoever.
I think he has a future interest.
He does have a future interest, that's correct.
From the conversation I'm hearing, I think the terms of the trust are pretty clear that he's supposed to be the owner of Kevin is supposed to be the owner of the property when the trust is distributed.
That is true.
I think that sounds like that's pretty clear cut. So at the very least, Kevin has some kind of a future interest in that property.
That is true, Your Honor.
Your Honor, I don't even. Go ahead, Judge.
Go ahead.
I don't like to characterize it as a future interest. It's a present interest. He has equitable title, and that is what we call season. He has achieved season by virtue of owning an equitable title. So it's a current. It's not inchoate. It's a current right.
And I don't disagree with that. I think he had a right, or he had some right in the property as soon as Mr. Moore passed.
Yes, Your Honor.
Pursuant to the terms of the trust. I would agree with you there. Here's where I'm at though. As much as I like to hear a new argument, I'm stuck with the owner has the right to evict. that's where I'm at. I'm more than happy to look at any kind of case law, look at briefs, whatever we're at. But at this point, I'm stuck with the owner has the right to control the property. And at this time, the owner is the trust, which is controlled by Mrs. Moore, and Mrs. Moore wants to pursue the eviction. So that's where I'm at right now. Mr. Ruark mentioned time to move out. So I'm thinking on the fly here. Unless, Mr. DePietro, you can give me something real good, my provisional ruling is that the trust has a right to possession based on their ownership.
May I address that?
Understanding that, I'm sorry?
I was simply going to say that I don't disagree with you. My position is that they are not the only persons in interest who have that right. That's my position.
And I understand that position. And going forward with what I was going to say is obviously Mr. Ruark isn't taking the position that Mr. and Mrs. Moore have to be out of that house in the next 3 days. So what I'm going to suggest is, you know where I'm at. I suppose either one of you could bring Kevin Moore into this with some kind of a joinder action. And we can set this for a date between now and whatever the agreed upon move out is for Mr. Kevin Moore to come in and take whatever position he wishes to take as to the possession. But I'm willing to hear suggestions from you two. This is obviously a novel argument for all three of us, I think.
Your Honor, here's my suggestion that what we do. He is correct that Kevin Moore has an interest in the property. I don't believe legally that precludes the trust from evicting, but that is a correct statement, okay? I would suggest, we adjourn for a couple of weeks. We get Kevin Moore in here. I don't think he needs to be a party. He can put on the record that he wants the trust to proceed on his behalf.
I think that would do it.
Yeah, I would think that would be fine. My concern is to avoid an appeal if at all possible. Well, so I would ask the court to go ahead and do something like that, and then to make sure that escrow is paid up to date.
Thank you, Mr. Rourke. Judge, why not, why bring him half in? He's a full owner, but for legal title. Why should we leave his interest hanging out there if we're going to be talking technicalities and appeals and such? If we agree that he should be in here, let's bring him in. I'll file a motion if you wish. And he can join and file an answer, and then everybody's covered. Plus, we know what his feelings are, and I think his feelings are important. He owns this thing. But for legal title, this is analogous to the land contract holder who's paid up the contract and can't get a deed. It's a huge ownership interest this man has.
I don't see any, Mr. Rourke, I don't see any harm with bringing Mr. Kevin Moore into the action as a party. Do you?
I don't see a harm in it. I don't think it's necessary. I can always have Kevin Moore sign a limited power of attorney, giving Glenda Moore as trustee the right to represent him and his interests. That would accomplish the very same thing. Again, my concern right now, my biggest concern is to avoid an appeal.
I guess my question is, why are they hiding this guy? Power of attorney, give Glenda a power of attorney. We've been through Glenda's powers of attorney. We don't need to go there. That would be a conflict on its face, by the way, Your Honor. The beneficiary giving the title holder power of attorney.
Is Kevin local?
Yes, Your Honor.
He can appear via Zoom. We can probably try to get him on the phone right now.
Let's bring Kevin in officially. Let's bring him in officially.
Who's going to bring him in, Your Honor?
Mr. DePietro will.
An oral motion or on a specific motion?
I'll file a written motion to add a necessary party.
When will?
I'm sorry. Go ahead, Mr. Rourke.
When will the motion be filed? Because I stipulate to it right now.
Well, you haven't seen it. I want to make sure we have a record, Judge. We need a record.
No, that's fine. When can you file something?
I have it filed within 2 weeks.
Your Honor, I'm concerned about escrow, that it's paid up to date.
It looks like, unless my civil department's backed up on these papers, it looks like the last receipt in the file is dated from July.
We need to have
Looks like
escrow
we got-
paid for July, August, September, October. That should all be paid. If we're going 2 weeks, we need to have this November paid too. So he must owe at least $4,000 in escrow to the court.
Mr. DePietro, do you have any input on that?
Judge, I'm not aware of the facts. Might I consult with my client to see if his figures are the same as the court's, or
Well,
if he has?
Look, I'm just trying to save some time. Let's just do this. Can we all agree that by the time we hear the motion, there will be no outstanding escrow payments?
I had no problem with that.
That would
Mr. DePietro?
That would require me just a brief moment with my client, Your Honor, who's in the courtroom.
All right. We can do that. Heather, put Mr. DePietro in a breakout with Mr. and Mrs. Moore, please.
Sure. Judge, Attorney Sandra Franick is also on a case with James Moore, but I don't see his other attorney.
Understood.
That's the only reason why she's in here.
Understood. Good morning, ladies.
Good morning.
Hey, Heather,
Yes, Judge.
call Attorney Gary Strauss,
Okay.
248-584-0100. See if we can get him on Zoom.
All right.
All right, ladies, this is going to be very disjointed because I want to get started with you while I'm waiting for these folks. Then I'm going to pause you and try to finish up with them.
Sure.
Ms. Riopel, are you ready?
I am.
Ms. Fletcher, you ready?
Yes.
Okay. So ladies, last time we spoke, I set today to have a hearing to determine whether or not there are any damages. I think we talked about maybe an outstanding water bill, so on and so forth. Is that, we're all on the same page? That's what we're here for?
Well, she was supposed to move out October 1st.
Okay.
So I'd have 19 days to get
Right.
estimates for damage. She moved out Friday at 4:30. I got the keys.
Okay. So you want to adjourn this so you have a chance to assess damages?
I've got some quotes and stuff, but I don't have everything.
It's up to you. I agree. You were supposed to have some time. So if you need more time, just tell me.
I would love more time.
Okay. Looking at my calendar. So I'm assuming you want to go into November to get your paperwork together?
Sure.
Any objection?
No.
How about Tuesday, the 2nd in the afternoon?
Sure.
2:30?
Great.
Ms. Fletcher?
Agree.
Okay, thank you, ladies.
Thank you. May I just ask real quick, will pictures, the site, work for?
However you want to present, pictures, video. Pictures are easier because with video, I'll probably have to get my tech guy involved. But if you got printed pictures, we can hand them around the courtroom that way.
All right. The video is nice because then you can zoom in.
And that's just a little bit extra effort here. But
Okay.
whatever, it's your case, whatever you think is the best way to present.
Great. Thank you.
See you then, ladies.
Judge, I called that attorney's office, went straight to voicemail, but I did leave a message.
Thank you. All right, Mr. DePietro, as to escrow, any reason why it cannot be paid up by the motion date, whenever that's going to be?
No, Your Honor. In fact,
Okay.
it's paid through September, according to my client. He has receipts, but that's irrelevant. We'll just make sure we're
Okay.
clean.
Okay, then I'm gonna suggest, Mr. Moore, next time you get a chance, come on in with your receipts, because my file's only showing July 8th as the last receipt. And it's, once again, it's possible that it's in the civil department somewhere. It hasn't made its way into the file yet. So Mr. DePietro is gonna file a motion within 2 weeks. Mr. Ruark, I'll give you some time to respond. Let's look at a date.
Your Honor, I'll have my response in almost immediately. I request that the date be 3 weeks out. I would waive any deadlines that I may be giving up.
All right, so you're looking at the week of November 8th, correct?
That would be 3 weeks out, yes. It's wide open for me.
All right. Heather, any reason why we couldn't do this on the afternoon of the 9th or 10th? Actually, we could do the morning of the 9th as well. I'm doing arraignments, but I can work around arraignments.
Correct.
So morning's better than afternoons, people?
I can do either on the 8th, 9th, or 10th.
Judge, are we talking oral argument on that day?
Correct.
Give me a second, Judge. I'm trying to get the calendar up.
Yep.
That's Tuesday the 9th in the morning, Your Honor?
I could do either one, morning or afternoon, whatever works for you guys.
AM's fine with me.
I can do the morning.
All right, so how about November 9 at 9?
Very well, Your Honor. Thank you.
And so the
And we
motion
can
will
do
be
that by
filed by the
Zoom.
1st of November.
Mr. DePietro, your motion will be filed by November 1?
Is that 2 weeks, Judge? Yes, sir, it is. Yes, Your Honor. Yes, Your Honor. Yes, Your Honor.
It is.
Yes.
Okay. All right. All right. Anything else today, gentlemen?
So the escrow will be paid up by the 9th of November then.
Correct.
Okay.
Thank you, Judge.
Would that include November
Thank you.
escrow, Your Honor?
It should. It's been due on the 1st of the month, so. Mr. Moore, have you had any conversation with Gary Strauss?
You know, he might still
You're
be
muted.
stuck. Is he still in the room, Judge?
No, Mr. Moore is muted. Mr. Moore, you got to unmute your computer. Mr. Moore, have you had conversation with Gary Strauss regarding today's hearing?
No.
Okay. All right. We're trying to get a hold of him for the Bank of America case.
Okay.
So Mr. Moore, we'll put you back in the waiting room to see if Mr. Strauss shows up. Counsel, I'm going to give Mr. Strauss a few more minutes if you don't mind. And then
Judge.
Mr. Ruark and Mr. DePietro, I think we're done with you. Have a
Thank
great
you,
night.
Your Honor. Thank you, Judge.
Sorry, Judge. We did have a
Yes,
case
ma'am.
with Mr. Struss yesterday, and he did not appear. I'm not sure if he's still hospitalized.
Oh, I
So
didn't know
I
he
was
was
gonna-
hospitalized. Okay.
Yes, I was gonna simply request, because I know we adjourned this case previously. I would agree to another adjournment, and we did file a motion for summary, so I would just simply request that the motion and pretrial be scheduled for the same day and time if possible. Just to give him another
Any objection
opportunity.
to that, Mr. Moore? Mr. Moore, any objection to that adjournment?
No ejection, no.
Okay. Counsel, do you have a date on the motion yet?
We do not, Judge. I believe we mailed it out on the 14th, so I'm not sure if the court's received it yet or not.
Why don't you do this? Why don't you check in with my civil department this afternoon?
Okay.
And get that date set up so they can get the notices out soon to Mr. Moore and Mr. Kraus.
Okay, so it would be, so the pretrial and the motion will be set for the same date and time then?
Sure.
Okay.
Sure.
Okay.
No reason not to.
Okay, thank you, Judge.
I have one
All right,
question.
Mr.
Your
Moore,
Honor.
yeah, go ahead.
This is our second case here. First of America, was this discussed in the last council?
I don't understand your question.
Were we talking about what we're talking about right now in front of Mr. Rourke and everybody else?
Only to the point where I asked you if you heard from Mr. Strauss.
Regarding the Bank of America, okay.
Yeah, then they left the meeting before we talked about motions and adjournments and all that stuff.
Okay, yeah, I just try to keep things, go ahead, Elise.
No, I understood.
So they're aware of the Bank of America case.
I'm sorry, Ms. Moore, you were garbled to start with?
So they were,
Are they-
so they were aware of the Bank of America case.
If they were paying attention, they are.
Okay.
Yep. Anything else?
I'd just like to keep it private and separate. Thank you.
Well, that's kind of hard to do, Mr. Moore, when it's not private proceedings.
I see.
Just like if we were in open court, I'd be calling files in open court, just like I'm calling them in my Zoom meeting room, but I'll, to the best of my ability, I'll try to do that.
Okay, I appreciate it. Thank you, Your Honor.
Yep, have a good day.
Yes.
Thank you, Judge.
Yes.
Counsel, you'll contact Civil Department?
Yes, Judge, we will. We'll get that set up.
Thank you.
Thank you.
And Heather, it appears that I am not the co-host. Good morning.
Oh, Judge,
What's going
I'm
on?
sorry.
You getting your own little nickel tour? Yeah. What's new?
So those aren't around, but everything that happens there. Just happened to be that they were on. Very cool.
The next one is Providence versus Dilling Bank. We only have the Providence attorney, Velez.
Thank you. What's going on, Ross? Good. Good morning, counsel. Your appearance for Providence, please.
Morning, Your Honor. Attorney Ian Morton, Appellate's Law, on behalf of, was it Harbor Club, P67892.
And what time were you scheduled?
9 o'clock.
All right, Mr. Dillenbeck is not in our waiting room. I don't see.
I do have some additional information.
Go.
Was it Mr. Dillenbeck has had communication with my client. He has agreed that he intends to vacate. Was it by the end of this month? So we would ask that if this thing can be reset for, you want to set it for the 2nd? That way I know, I might be able to know by the 1st. If so, I can just do a notice of withdrawal.
I guess I can do that. Just so you know, I'm not going to have time for a hearing that day.
Understand completely, Your Honor. Was it, like I said, there's an agreement, he's getting rent waived, it's a good deal for him, so.
Yep. Understood. All right, so let's adjourn until the 2nd at 2:30.
Thank you. What time again?
2:30.
Thank you very much. You have a good day, Your Honor.
You as well.
I'm gonna bring in Mr. Cox and Paschal because I don't know who either one of them are. Unless you know.
Cox is the attorney, but I don't know what file he's on.
Right, I don't know. Yeah, right.
Yeah, let's find out.
And Sheila Siegel. Hi, Mr. Cox. What case are you here on today?
Good morning. I'm here on the matter of Michigan Education versus Thomas.
So you're here for Miss Winters?
Correct.
Okay. So I'm going to bring in Sonia Thomas. Paschal, what are you here on, please?
Oh, I'm sorry. That is Kingsley Okoro. I'm trying to correct it.
I'm sorry?
That is Kingsley Okoro. I'm just trying to correct that name. It's not.
I see it. I'll change the name and put you in the waiting room till we're ready for you.
Okay, thank you so much.
You're welcome.
Hey, Sandy.
Yes, Judge.
You heard anything from Attorney Burnt on Cash versus Qua? 845?
No, I have not.
Nothing's come in on that one, or, okay, thank you. All right, Mr. Cox, your appearance for Michigan Education Association.
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Good morning, thank you. And Ms. Thomas, you can hear me okay?
Yes,
Thank you, good morning.
good morning.
So today's a date and time to deal with objections to garnishment, correct?
Yes,
All right. Mr. Cox, did you see the objections filed by Ms. Thomas?
Yeah, Judge, I guess plaintiff's position relative to the objections are that she's attacking the underlying judgment. You know, the requirement to do that would be to file a different motion and come forth with an affidavit of facts setting forth the meritorious defense as well as good cause. She may or may not have good cause, but that's not what's before the court today. Today is objections to garnishment, and the defendant has not set forth one of the 5 statutory bases by which the court might grant her relief. So on that basis, the plaintiff is of the belief the objections need to be denied.
All right, Ms. Thomas, any response?
yes, my response is things have changed since I've been to the courthouse. I need to see what I can do at this moment. I was denied a home, but right now I'm homeless, me and my 2 kids. And so Friday I was denied because of garnishment, and I need to find housing. So right now I have $800 in my account. They've already taken out $500. If I could settle with the $800 that I have in my account today so that I can move my family into a home so that I can stop this garnishment, or if I can wait until I can secure housing before they resume their garnishment. The most important thing for me right now is just to get my kids into a home. So,
all right, so why don't I put Mr. Cox and Ms. Thomas in a breakout room so you can talk about it?
That sounds good, Judge.
Thank you.
Okay, thanks, Heather.
Yep. I'm going to bring in Sheila Siegel. Sheila? Sheila Siegel?
Good morning.
Good morning. What case are you here on, please?
For Marilyn Nyman Cohn on Oakland Community College versus Kingsley Okoro.
All right. And who are you on that? You're the attorney?
Yes, for Marilyn Nyman Cohn, correct.
Okay, thank you. And at 9:30, Judge, we have Willow Glen versus Garnett's. We do not have Mr. Coslin for Willow, but we have Mr. Garnett's. Should I call Mr. Coslin?
Sure, if you got the phone number, Andy.
Yeah, I can look for it.
Oh, great. Thank you.
This is a business card. I think she would be better off
Going there?
going there because they're more,
More retail?
well, yeah, and they actually have more parts for some stuff than the other place. You know what I mean?
Yep, thank you.
Okay,
Appreciate that, John.
make lunch today?
I think so. I'm not sure yet.
All right.
Yep, I'm gonna try to. It's been too long.
Clint's not gonna make it.
You all right?
Yeah, he's got something else going on. He ended up catching the COVID 5 weeks ago, he thinks. You know, 90%. I think he was double vaccinated too.
Yeah,
Did you get any more stuff?
getting more stuff.
Any more vaccines or anything?
I'm not
Booster
doing,
shot?
I'm not getting any shots. I didn't get the first round.
I know that you had it.
I'm
Same
not,
same as I
yeah,
did.
I'm not doing any of that stuff. Talk to Al. Jesus, he keeps sending me stuff, more and more information coming out that the people that are getting sick most are the ones that are getting already had their both shots.
The priest, his sister went on a pilgrimage.
Yep.
Okay, there were 60 people on the bus, all of them totally vaccinated. All of them got it.
Yeah, Jesus. So why take the chance and get the shot?
You know, the natural thing is better.
Absolutely. Yeah, absolutely. Yep. Yep. So I agree with you 100%.
All right, Adam, I'm gonna catch up with Al.
All right, see you.
I gotta see the sun.
He's doing a tour with some people right now.
He's what?
Giving some people a tour.
Okay, I saw him talking.
Can say.
Counsel, your appearance for Oakland Community College, please.
Your Honor, Sheila Siegel appearing on behalf of Marilyn Nyman Cone for plaintiff Oakland Community College.
Good morning. Mr. Okoro, you can hear me? Can you hear me, sir? I can't hear you. I can see your lips moving, but I can't hear any volume.
He needs to just talk up louder. Mr. Okora, talk very loud.
Is it better
No.
now?
No.
Let me link up on my phone and see if it will be better though.
That's better. Counsel, what do we have scheduled today?
It's the defendant's motion for installment payments. It was adjourned once, admittedly at our request. The judgment was entered back in June. We received no payment.
Okay.
But apparently there's a garnishment that's been submitted, so. And he filed a
All
motion.
right, so
for
Mr. Okoro,
installment.
you filed a motion for installment payments at $150 per month, correct?
Yes, Your Honor.
Okay, and did you see the objections that were filed by Oakland Community College?
Yes, I saw it, and I found out that it was concluded already, and at that moment there was nothing I could do. I only wanted just.
Okay, sir, I can't understand anything you're saying. I'm getting an echo chamber.
Oh, Lord. Your Honor, would you want me if I join with my phone?
I can't understand you. Sir, try to give me your phone number. I'll call your phone number.
313 407 8739.
All right, shut off your audio on the computer.
All right.
All right, that's better. Not as much echo. Did you see the objections filed by Oakland Community?
Yes, Your Honor.
Okay.
Like I said, it was concluded already. So all I be granted the installment payment.
Understand, but they're objecting to the amount.
Okay, let me see how much they want.
Counsel, I think your suggestion in your objections was 300 a month instead of 150 a month.
Well, every pay period, and we can put that specific amount in the garnishment. We can prepare an order amending that garnishment. That's going to be a lot less than what he would get taken pursuant to that garnishment. And he makes a healthy amount of money, and his, I mean, he didn't indicate all his payment or his expenses, but his rent is well below the 25% they recommend, that you know, finance.
So Mr. Okoro, what the suggestion was 150 per pay period, not 150 per month.
Yes, 150 per pay period, I agree with that.
Okay, that makes it easy. I can put that in an order. How soon can you start that?
I get paid every Friday. Can I start from next week?
That would be the 29th, agreed?
Yes, Your Honor.
So, Your Honor, we can't have it via the garnishment.
It wouldn't be a garnishment then if it's got that would be you'd have to set that up with the employer as an automatic pay withdrawal.
Well,
garnishment is 25% of his take home.
Yeah, actually, we have amended garnishments, but, all right, so, if there was no order submit, that's fine. So it'll be 150 every 2 weeks.
Every week.
Every week, 150 every week. That's fine. And it'll start
Okay.
29th, which is next Friday.
That'll start on October 29. The garnishment will be suspended. Agreed?
Any payments that were received would go to plaintiff, obviously, correct?
Correct. Agreed, Mr. Okoro?
Yes, Your Honor, I agree.
All right, thank you. Good luck, sir.
Thank you very much, Your Honor.
You're welcome.
Judge, I'm bringing in Mr. Garnett. Sandy said that they received a dismissal on the case and he's not needed this morning.
Thank you. Mr. Garnett, can you hear me?
Yes, sir.
My civil department informs me that they received a dismissal from Willow Glen. Understood?
Yes, sir.
All right. Any questions, sir?
Nope.
Have a lovely day.
You too.
Thank you.
Thank you.
Matthew Cooper. Oh, the attorney for Midland. Okay, now I see it. I'm bringing in Anissa Guyton, judge for Midland Credit versus Anissa.
Good. Counsel, your appearance for, well, wait, hold off on that. We don't have Ms. Guyton in yet.
Our first one this morning, we were doing so well.
Yep.
She's ready now.
All right, counsel, your appearance on behalf of Midland.
Good morning, Your Honor. Matthew Kuipers as coverage counsel on behalf of Midland Funding.
Ms. Guyton, can you hear me?
Yes.
And could you hear counsel's appearance?
I'm not sure. Was that the person that just spoke?
Correct.
Yes.
All right. Heather, would you have Andy call the department on that arraignment?
Sure.
Looks like we can get that in. All right, so ma'am, you filed an objections to garnishment?
Yes.
Counsel, did you see that?
Judge, I believe there's actually 3 motions before the court today. There's an objection to garnishment. There's a motion and affidavit to set aside a default, and there's also
I just see that, yep.
Motion and affidavit for installment payment.
Okay. Well, let's talk about the motion to set aside the default first. Ma'am, when I look at a motion to set aside the default, there are a default judgment. There are 2 questions that I have to address. Number 1, is there a good reason? In other words, did you have a good excuse for whatever caused the default? And in this case, I believe the default was entered because you did not file an answer. And then the second question is, do you have a meritorious defense? You understand those questions, ma'am?
Yes. What was the second one? Meritorious. What did you say? Defense.
Yeah. Do you have a good defense to the underlying claim against you? You understand the questions?
Yeah.
All right. I'm going to give you a minute to think about those questions while I talk to some folks on another file.
Okay.
All right, Mr. Cox, Ms. Thomas, you've had a chance to discuss this matter?
We have, Judge. I would characterize this as a tentative settlement. I believe the amount that she's proposed is going to be within the amount that my client will accept, except my settlement authority is a little different post-judgment than it is pre-judgment. I reached out to my client via phone. I had to leave a voicemail message. We exchanged all information. My expectation is that we're going to agree on this 800. She's going to pay it today, and we're going to do a satisfaction of judgment and garnishment release today. That's the thought. My other thought would be maybe to adjourn this 1 week, and then perhaps she could piggyback off this and do an installment payment order if my client is too stingy to allow us to get this done.
All right, Ms. Thomas, you agree with all that?
Yes.
Can the court accommodate this in a week?
I think I can. Heather, can we do this on the 26th?
We're still waiting on the
I'm thinking in the afternoon.
Yep, we already have civil here at 2 p.m. and 2:30
Okay.
on the 26th.
So let's do it the 26th at 2:30.
So, Ms. Thomas, this is if everything goes sideways and doesn't work out like we're hoping it does. We would come back on that date, and then I guess I would not object to you moving the court for an installment payment order, given that that might be where we need to go next if we really can't get. But I'd be very surprised. I think I gave it an 80% chance of likelihood of settlement, Your Honor, maybe higher.
Okay. All right. Ms. Thomas, any questions, ma'am?
No, thank you.
All right. Good luck to you.
Thank you.
All right, thank you, Judge.
Bye.
All right, we're back on with Midland versus Guyton. So, Ms. Guyton, let's talk about the first one. You did not file an answer to the lawsuit, correct? You're muted, ma'am. Ms. Guyton, you're muted.
Can you hear me?
Now I can.
Can you hear me?
Yes.
Okay.
So you were defaulted because you did not file an answer to the lawsuit. So what was the reason that you did not file an answer?
I didn't file an answer to this lawsuit because I don't feel I wasn't given proper notice of it. I had a legal address. Is no reason why my mail should have been coming here, because I had a legal address in since about August or so of 2020. And I just changed it back on June 30th, I think it is. I got my license paperwork. I'm sorry, I'm just getting off from work, and so I don't have everything out, but hang on, I'm gonna tell you the exact dates. So there's no way they should have pulled up my name and did any search with my name and should have been getting this address. I mean, it was changed with the post office and the Secretary of State.
Okay, so when did you first know about the lawsuit? When did you find out and how did you find out?
Okay, first of all, I found out at the court. I had come up there for something else, and then she did a printout, and then we seen all these, it's actually 2 different case numbers, and that's when I found out about it. When I found out about it, I found out about the garnishment up at the court. The court lady told me, because during the same time I had...
Hold on. When you found out about the garnishment from the court clerk, that was the first you knew that Midland was suing you?
Yes, because she told me I would be getting some paperwork from my job and that you guys had got something, I think it was stamped for the 10th. But she said, just wait, because she said there's nothing I can do, that the job would be sending me some paperwork about.
Yeah, but that's talking about the garnishment document, correct?
Right. You asked me, when did I know about it?
I'm talking about the underlying summons and complaint that started the lawsuit. You never received that. The first you knew about a lawsuit was when you came up and found out about a garnishment, correct?
Yeah.
Okay, so the next question is...
When I came to the court, it wasn't about the garnishment. When she pulled my file, because
I understand that. You were in here about a different matter and found out about this one. Right?
Right.
Okay, so then my next question is, what is your defense to the claim from Midland Credit Management?
Hello?
Yes, ma'am. They're suing you. They're suing you, and I want to know what your defense is.
Okay, what am I answering now, as far as the court case, or what am I defending myself on? Because I put a lot of papers in.
You filed a number of motions. One of them is the motion to set aside the default judgment. That's what I'm currently addressing. My question to you is, what is your underlying defense to the claim against you from Midland Credit? They say you owe money. What's your defense?
I don't owe money. I don't owe them any money. And this whole claim, I think, come out of being vindictive, because at the 1st of January, I reached out to a credit cleanup person to like help build your credit. And we sent out papers to 3 different people about asking, it's like a paper where you demand proof and how you owe the person and what for. That went out to Midland and another place that was on my Equifax at the end of January, the top of February. Never got anything from them. And then now I had this court notice. And then looking at the court register, this started all around that time. I don't have a contract. I have never done any business with Midland Credit.
Okay.
I don't even know what money's there. So I don't even have information on the monies they're suing me from, or where they're saying they got it from.
Did you ever have a credit card with, ma'am, could I speak now?
Uh-huh.
Did you ever have a credit card with Synchrony Bank or GE Capital Retail Bank?
No.
Judge, it's actually a PayPal credit card. Synchrony Bank is just the underlining company, but
thank you, counsel. Ms. Guyton, did you ever have a PayPal credit card?
Yeah, I had a PayPal card.
Okay. Well, unless you had more than one, that's what this lawsuit's all about.
Okay.
Understood?
Uh-huh.
Okay. So understanding what this claim is, what's your defense to the claim?
That I don't owe Midland Credit anything.
Did you owe money on your PayPal credit card? Because that debt has been assumed by Midland.
Not that I'm aware of, because my credit card was closed by PayPal at the top of COVID, and my bill wasn't due or anything. They closed it out of protection for them. Like, how did the lady tell me? Like just in case, she said that they can close it at any time. When all this COVID stuff started, they just closed it like to protect them because everything was shut down.
How would closing your account protect them, and protect them from what?
My assumption was to protect them because the whole world was shutting down. So they didn't want people, using credit and couldn't pay it back. Nobody could go to work, nobody, nothing. My card at the time was not in good standing. So when I was like, well, why is it being closed? It was like, that's just something credit cards do.
At the time PayPal told you they were closing your account, was there a balance on the account?
I don't even remember, honestly, but at the same time, they ended their contract with me.
Okay, your motion to set aside the default judgment is denied. Next question is the motion to object to garnishment. Anything you want to add to that?
Yeah, a couple things. What I had just mentioned to you, and I'm sorry, I'm just getting off work. I have to put the phone down to get my paperwork. I'm actually even still sitting in the car right now. But I had started with a credit cleanup girl at the first of the year. So they never even responded with that. They responded with, I suppose, this garnishment. Because like I say, I got this information when I filled out these papers. That's why I filled out everything that the lady gave me. So I don't think them not having a default judgment. Well, then you just set aside the default judgment.
Pardon me?
Did you not just set aside the default judgment?
No, I denied your motion to set aside the default judgment. I don't think you have a meritorious defense to the claim.
With them giving me proper notice? Because
they did give you proper notice.
No, they did not. They sent this information to an address I didn't reside at, and I have my registration and change of address here to show you.
Okay, Ms. Guyton, I'm the one that gets to decide if proper notice was given, and I decided it was. They sought an order from the court for alternate service. They did everything that order required. That means you were properly served.
But that order went to an address that I had legally changed. How can I be properly
I am not going to argue with you. I have made my decision on that motion. You are fully within your rights to appeal that decision, but you don't get to argue it anymore today. I've made that decision.
Let me
the next discussion is about, ma'am, I'm not going to argue with you, and you're not going to interrupt me. I will just kick you out of my meeting.
I'm trying to understand.
Then let me talk without interrupting me.
I have. I heard you say that they asked for.
I have ruled on your judgment, motion to set aside the judgment. I have denied your motion. The judgment stands. The next question is your objections to garnishment. The way I understand it, you're objecting to the garnishments because Midland did not cooperate with your debt consolidation company, correct?
They never sent any information to us.
Ma'am, I've asked you a yes or no question. Is that your argument, yes or no?
Yes, they never sent anything. They never answered.
Okay.
They never answered.
There's no requirement. Ma'am, Midland is under no obligation to deal with your third-party debt consolidation company.
It was no third party. I sent in myself all the paperwork I filled out with my name, my address, and asked for the information directly. The third party did not reach out to them. I did. They were just directing me as to what to do. So anything and everything they got came from Anissa Guyton from Glastonbury. So they even
And when
had
did you send that?
address. I sent that at the end of January, the top of February.
20 or 21?
21. Wait, no,
Which would
we're
have
in
been
21
after the
now.
default judgment.
No, this is in 20. This was at the top of COVID. I'm in 21 now.
All right, so in January or February of 2020, you sent them a request for some information.
Right. We're in 20. Hold on, let me get my dates right. This is
2021. This is October of 21 now.
COVID started in March, so it would be of 21. Yes. And if
All right,
you
now
give
you're
me,
you're confusing me. You're confusing me. At some point, you sent a request for information to Midland. Was that done in January, February of 20 or January, February 21?
January, February of 21. We was in the midst of COVID.
Okay, which was well after they had a default judgment against you. Would you agree?
Yeah. No,
Okay.
before they had a judgment against me.
Judgment was issued June of 2021. June 2.
Say that again.
The judgment is June 2, 2021.
Okay. All right. But ma'am, you told me that the first you knew that Midland was suing you was when you got notice of the garnishment.
Correct. From the court lady.
So why did you send them a request for information in January if that was before there was a garnishment? You must have known about a lawsuit if you sent them paperwork.
No, I sent them paperwork because I was just plain old trying to clean up my credit. I just got out of a lawsuit from a car accident and I had doctor's bills.
Okay.
So I called them saying, I know they coming because I owe. Pardon me?
Okay. I got it now. So you were just trying to figure out who you owed money to, so you sent something to Midland.
Right, because that's what had come up on the credit report that they pulled at the time.
All right. So there are specific reasons, valid reasons that you can object to a garnishment. One of them, for example, is if they were garnishing your Social Security check, they can't take your Social Security check. If they were garnishing some other protected funds. So for example, let's say there's a Mr. Guyton and you've got a joint bank account with Mr. Guyton and the garnishment went after the joint bank account, then that might be a valid objection. So I need to hear from you one of those stated reasons. All I'm hearing from you is they didn't respond to your letter, so you don't think they should garnish your check. Is there another reason, or is that the only reason you've got to object to the garnishment?
I'm saying that when they came to the court in the beginning, as if they couldn't find me, it was under false pretenses. I sent this letter to Midland and Nationwide at the top of February, even with my current address at Glastonbury in Detroit. Yet none of the notifications they sent out to me, they sent to Romulus, where I was not at, where my license was changed with the Secretary of State and with the post office. Why couldn't they serve me properly at that address at 19480 Glastonbury? Even that paper I sent them at the top of February had the Glastonbury address on it.
I'll let counsel respond to that.
Judge, the only thing I can explain is that for some reason or another, plaintiff believed that the address was the 6331 Carnegie. We did seek an alternate service order for that, which was granted, and we did effectuate that order according to the order.
Counsel, sorry to interrupt, but did plaintiff do a postal check? I'm looking in the file that's normally part of it.
I don't see one in the documents I have here, Judge. Normally, if one was done, I'm assuming it would have been attached to the motion seeking alternate service.
Yeah, I found it. So this is dated January 5, 2021. Looks like the process server actually did the request. Name, Anissa Guyton, address 6331 Carnegie Street, apartment 101, Romulus, Michigan. And as of January 5, 2021, the post office said no change of address on order. So ma'am, that's why Midland pursued this action at the Carnegie address, is because as of January 5, 21, the post office said that was the address for you.
That's not true. I changed my address at the post office in Detroit at 7 Mile off of Southfield, and I changed my address with the Secretary of State on my license. There's no way they shouldn't be sending my information to Glastonbury.
I'm not saying that that's not true. I'm answering your question. Your question was, why did Midland go after you at the Carnegie address? And I'm answering your question by saying, as of January 5, the post office told the process server that that's still your address.
And I'm going to take this on here on 7/5 of 20 is since when it's been changed. Since before then, because it take that long for the paper license to expire. I've been out there for over a year for a job. So there's no way.
Anything else as to the garnishment?
I'm also filing bankruptcy.
Okay, which has nothing to do with the garnishment. So your objections to the garnishment, I rule invalid, and any funds will be released to plaintiff. Next item is your motion for installment payments. What are you proposing for payments?
I'm not even sure what I put on there. I think $25 a week.
You put nothing on here.
Yeah, I did. I remember that.
I believe she put $25 a week. She was correct.
Oh, okay.
Or $100 a month.
$25 a week, ma'am?
Yeah.
Counsel, what's your outstanding balance at this time?
The outstanding balance is $2,563. Just so the court's aware, we're getting on average $135 a week via a garnishment. At $100 a month, it would take 3 years. At the current garnishment rate, it would take 5 months. Therefore, plaintiffs requesting that the garnishment be allowed to stand.
Yep.
Hey,
I'm not going to go.
A year. I have not been working a year. I don't even have 6 months on
Ms.
the job.
Guyton, I am tired of talking over you.
How are you talking over me?
Because you keep talking when I'm not addressing you. So don't speak unless I ask you a question. Clear?
Yep.
I will not sign an installment payment order that takes more than 3 years to pay off a debt. If you'd like to reassess your offer for an installment payment and put another number on it, I'll consider that.
What would the divide be to make it 3 years?
I'm not going that far out. Counsel says they're currently getting 150. How much? Counsel?
About $135 a week, Judge.
All right, they're getting 135 on the garnishment and you're offering 25. You're going to have to get closer to the garnishment amount for me to determine it's reasonable.
Can I do half of that a week?
I'm sorry, half?
Yeah, half of that.
You said half?
Yeah.
Let me do the math. Hold on a minute.
Or if that'll take 5 months, you said that'll take 5 months. The Matthew Coppers guy is stay on here. You said that what you guys are taking will take 5 months.
Based on my calculations, it'll take between 5 and 6 more months, correct?
5 or 6 months. So can I do $50 a week? That should be a little more than a year.
So you're offering 200 a month, ma'am? Ms. Guyton?
I don't have much of a choice.
Well, you can always file bankruptcy. I'm trying to avoid that. I'm asking you what you can afford for counsel.
I told you what I could afford.
Then I deny your motion. Any questions,
So you're
ma'am?
not gonna even accept the $50 a week?
I'm
when he
denying the
paid-
motion you filed at $25 per week.
But what about the $50 a week?
You can file a motion on that and I'll address it then.
Okay.
Counsel, anything necessary for clarification purposes?
Judge, did you need plaintiff to submit any orders or?
None. I've signed all the orders.
Understood. Thank you, Judge.
Judge Williams' iPhone is the Van Buren Police Department. They were unable to, they had
Thank you.
problems with video.
Who's Lorenzo Thomas, do you know?
He's a 1030 waiting for Sydney Katz's office.
That one was dismissed.
Pinewood versus Thomas.
Yeah, I think that's what Sandy said. Sandy, is that what you told me? That one was dismissed?
Yes, Judge, that one was dismissed.
Do you want me to bring Mr. Thomas in?
Just did.
Okay.
Mr. Thomas, can you hear me?
Yes.
Mr. Thomas, the case with Pinewood Circle was dismissed.
Okay.
Understood?
Yes, sir.
Have a nice day.
Thank you.
All right, we got Van Buren.
We do. Step on up here.
Good morning.
Good morning. It's also the same thing with Van Buren Township. I have Rachel Cooper here.
Thank you. Good morning, Ms. Hooper.
Good morning.
Ms. Hooper, I understand that you've decided to go forward today without an attorney. Is that correct?
Yes.
All right, you're to be arraigned today on a misdemeanor charge of domestic violence. The date of the offense was October 17, 2021. The charge carries a possible penalty of up to 93 days in jail, up to $500 fines plus court costs. Do you understand the charge and the possible penalty, ma'am?
Yes.
All right, I've got your address on Gilmore Street. Is that correct?
Correct.
Phone number 972-0097. Is that also correct?
Yes, sir.
All right. I'm going to enter that guilty plea for you. We're going to set a court date for a pretrial for November 9 at 9. The nice officers that are with you are going to give you a written notice with that date on it. Our case number for Ms. Hooper is 21-0771.
Got it.
Thank you. And Ms. Hooper, are you working?
Yes, sir.
Where do you work?
I work at Air Margaritaville in the North Terminal at the airport.
All right. How long you been there?
I've been with my company for 5 years.
Okay. All right. Any criminal history, ma'am?
No, sir.
All right. I'm going to put you on a personal bond with 2 conditions. Number 1, well, actually 3 conditions. Number 1, stay out of trouble. Number 2, cooperate with us so we can have a pretrial on November 9. That'll be by Zoom, the same way we're meeting now.
Okay.
And the 3rd condition is I don't want you to have any contact with James Mercurio. Is that going to cause any problems if I order no contact between you two?
No, as long as I can get my car and my work clothes from the
Right.
house. That's all. I mean, we do
You
share
work-
residence. I just need my things to go to work.
All right, where's that stuff located?
My car is at the house in the driveway.
That's
And my
Gilmore
things-
Street?
Yes, sir.
All right, so you can go back with the police department. You can set up a civil standby so that the police can go with you to pick up personal property. Now,
Okay.
understand, they're not going to mediate. If you say the car is yours, but it's in both your names or something like that, then
No,
the
it's in my
police aren't
name.
going to mediate that. Okay.
Yeah, no, it's in my name.
All right, so I don't want you to go back to that location other than with the civil standby with the Van Buren PD to pick up personal property.
Okay.
No contact, no phone calls, no letters, no social media contacts. Don't reach out by Twitter, Facebook, Instagram, or whatever anybody else is using on that stuff. Don't have third parties contact him on your behalf. If you see him at Taco Bell, you're eating burgers. No contact at all. Understood?
Okay. Yes.
Do you have any questions?
No, sir.
Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on bond?
Yes.
If you mess up, you're going to jail. You're going to have to come up with $1,000 to get out. Understood?
Not gonna happen. Yes.
Do you have any questions about your bond conditions?
No.
All right, good luck. Thank you, officers.
Thank you, sir.
You're welcome.
Judge, Attorney Ryan Hill was also on that Lorenzo Thomas case.
Representing who? Oh, Mr. Thomas.
Yes.
Why didn't Mr. Thomas tell me that? Good morning, Mr. Hill.
Morning, Judge.
We were informed by Sidney Katz's office this morning that the matter had been dismissed.
Okay, I just want to make sure the court was aware my client moved out.
Yep. I'm assuming that's the reason for dismissal.
I hope so. All right, I just wanted to make sure. Thank you, Judge. I appreciate it.
You're welcome. You have a great day.
Take care.
So just leave it up and running for this afternoon?
The leftovers, yeah, that makes sense.
Yes. Hi, Darius. For Darius iPhone.
How like this?
Yes. What is your name?
Raven Whitehead.
All right, I'm going to put you back in the waiting room until we're ready for you. Just so you know, it does start about 1:30.
Oh, okay.
All right.
Okay.
Thank you. Hi, Samples.
Hi.
Hi, are you here for Levine?
Yes.
Okay, I just wanted to verify. Oh, so you're the manager. Okay, okay, at West Village. All right, I'm gonna put you back in the waiting room till we're ready for you, okay?
Thank you.
Thank you.
Heather.
Yep.
So do you want to make me co-host so I can see who's out there?
Yes, I will. Let's see. The only thing for some reason, check and see, can you do breakout rooms or no?
No, I cannot.
That is so crazy. Okay, because Judge used to be, we always have had this where Judge can do breakout rooms and now
Yeah. It
something
doesn't say
changed.
anything about breakout rooms down
Yep.
here. I can't even see them.
It changed, that's why.
So what? How do you want to do this today? What do you want to do?
You tell me what you need and I'll do it.
Okay, so like our samples. So how many breakout rooms do you have open?
I have, I think, 10.
3, okay, 4, 5, 6. Okay, so we need we need at least 6 of them. So
Yep.
you can name them, like I would name them like Levine, Ravitz, Applebaum. I would name them the attorneys' names.
Oh, I didn't know you could do that. I'm doing it right now.
Yes.
Okay, so type it, so make one Levine.
Mm-hmm.
Okay.
I usually start at like the top. So my first one would be Applebaum, then Ravitz, then Levine. I follow that down, although Levine's got a couple different ones, but that's okay.
That is such a neat idea. And then, okay, so Levine. So what do you want me to do when
after you're done doing that? So you know that our samples is for West Village, which is Levine. So you can bring her back in and tell her, we're going to just put you in the breakout room and you can wait there for the attorney, and, so you can just get rid of her out of the waiting room. So you're not clogging up the waiting room. So we know who's in there.
So they're all going to want to talk anyway. So as soon as these people come in, you just throw them in a breakout room?
Basically, yes.
Because you don't have to handle it.
Right.
It's all on them. Okay.
Mm-hmm. And then we can tell them just come, and then I just say, okay, when you're done, you can come back into the meeting and just let me know what's going on. And they'll come back in and say, okay, we have a consent judgment. So you just have to remember, consent judgments, if they want to go on the record, they can. They don't have to.
Okay.
Okay. And defaults are, just tell them that we'll take defaults at 2 o'clock. I'm trying to think what time is it. At 2 o'clock, they can, I'll give us all the defaults.
Okay. Well, let me bring Samples back in and throw her in Levine's breakout room.
Okay.
Hi, I'm going to put you in the breakout room waiting for Mr. Levine, okay? Thank you. So then how do I do that, Sandy?
You just assign her to it and she hits the join button.
Oh, there it is. Duh. Actually, she just gets pulled in.
Okay.
Okay,
I
so
see
now
on ours, we always had to tell them when you see that join a breakout room, you can go ahead and click it.
See, I cannot stand that. Kathy Bandy. Just bring her in and figure out what she wants.
Yep, and figure out what she's here for. I don't see her.
I don't either.
So then if she is, whatever she's here for, you can either put her case number on it, you can put Levine on it, you can rename her, like leave Kathy, but put Levine. And that way you know that she's here for that.
And I would shove her in a waiting room?
Nope, you shove her back in our waiting room, yeah, not
Okay.
in the breakout room.
Hi, Kathy.
Hi.
What are you here on, please?
I can't remember her name. It's 29 Brandy. Hang on one second here. It's Nestor and Stacy Chavera Calandras.
Okay. You have a case number?
Who are you, though?
I'm the manager at Park Estates.
So you're at Park Estates, okay.
Right.
So should I put her in the breakout room?
Yep.
Yes, okay. I'm gonna put you in the breakout room till Mr. Levine comes in.
Okay.
Okay, Sandy, see, here's the problem.
It won't let you put her in there with her?
No, because I allow, let me see, breakout rooms. Yeah, because she's not even on my, oh, forget it. I'm not reading it right. I don't know what, I think, I don't know what I think I was looking for Levine's name up at top.
Oh, okay, yeah.
Not sure.
So now sometimes like with Levine, he may want like Park Estates in one and West Village in another. If he wants that, then like we could make like 1, 2, 3 different breakout rooms for him and just name them different ones or 4 because I see he's got 4 different complexes. Sometimes they want that, sometimes, you know, it just all depends. But
all right.
So John Berncrant is here for, he's got 1, I think.
Yeah.
I know I've seen him somewhere.
Yeah, I'm bringing him in now.
Okay.
So just throw him in his breakout room until not even say anything?
No, you can tell him.
Hi, I'm going to put you in the breakout room waiting for the other party to appear. John?
Oh, okay, thank you.
Sorry, I didn't talk first. I'm sorry.
That's okay.
Is Kathy going to be joining you, John?
She is. Thanks, Sandy.
Okay, you're welcome.
Yes, she is. She should be on any minute.
Okay.
Who's Kathy?
She's Kathy, the manager.
For Gateway.
Yeah,
I see that MIMG.
Yeah, I know. You just have to read past all that.
Robert Novak.
He's an attorney.
He's not on here.
Yeah, he is. He's second one. Lee Ravitz, Birch Run. Yeah.
Oh, okay.
Yeah.
Is my tenant here?
She was here earlier, but she was here at 1 o'clock checking out her Zoom, and then she's gone now.
Oh, I thought we had an agreement and we were going to show up early and just kind of put it on the record.
Well, she was real early. She was here at 1 o'clock. You weren't.
But
she probably decided she'll come back.
I will patiently wait.
All right. So Sandy, should I put him in, or since they already
Yeah,
know?
you can put him in. Yeah, she's going to put you in the breakout room, and then when the other party gets here, we'll bring you back out.
Thank you, Sandy.
You're welcome. Yes.
Hi, Brandy. I'm going to put you in a breakout room waiting for Mr. Levine, okay?
Okay.
Okay, Sandy?
Yes.
Todd Barker is here, so is Maple Leaf, just not Levine. Do I just leave Todd in the waiting room?
As long as we know who he's here for, we can leave him there.
Oh, okay. And wait
He's
till
a
Mr.
defendant,
Levine's ready.
correct?
Correct, he's a defendant, yep.
Yeah, so I just wait till Mr. Levine gets here because he's not gonna be able to do anything until he speaks with him, so, yeah.
Okay.
You can bring him in and just, if you want to, I mean, it's not 1:30 yet, so I wouldn't even worry about it. If you want to bring them in, you can bring them in and just say, you know, I see you're here for, or what case number you're here for. I usually put their case number on or something to let me know that I've talked to them. So that way I don't, you know, that's how I do it, Heather, but you can do it however you want to. So.
Okay, I'm gonna, all right, thank you.
You're welcome.
Hi, Stacy.
Yes.
What is your name, please?
I'm sorry, say it again.
What is your whole name?
Stacy Chavarria Colindres.
Okay, I see you. Okay, we're waiting for all parties to come in, and so we'll talk to you in just a few minutes, okay?
Okay, no problem.
Recording in progress.
Hi, Miss Wilburn.
Good afternoon.
Good afternoon. Which cases are you here on? Are you here for all of Levine's?
Yes, so we've got Metro Commons, Maple Leaf South, West Village, and Park Estates.
All right, so I have a few people already here.
Okay.
Sandy, do you want to take over your spiel and I'll put her in the breakout room?
Okay, so Jen, defaults we'll take at 2:00. Okay.
Okay.
What she'll do is she'll go ahead and put you in the waiting room. If you guys have, if you come up with a consent judgment, just come back out. Let us know. If you want it on the record, we'll put it on the record. If you don't, you guys are good as long as they agreed to, you know, sign it and that. Okay.
Okay. Very good.
All right.
So I'll bring people in one at a time as they come in, I'll just throw them in there. Is that okay?
That works for me.
Okay, thank you. Hi, Stacy. I'm going to put you in the breakout room because everybody's available now for your case, okay?
Is Nestor going to be here, Stacy?
No.
Okay.
Should I give it a few minutes, Sandy, before I put other people in there?
Yeah, when she comes back out, then you'll throw somebody else in. But you've got Dakota Hoffman, who's an attorney, and Steve Robinson. You can bring those guys in and put them in their breakout rooms.
Okay.
And just let them know that, you know, the consents and.
Dakota, you're here for Mr. Applebaum?
I am.
Okay. All right, I'm going to put you in a breakout room. If you want, what is it, Sandy? The consent.
Okay, so if you guys get a consent judgment, you can go ahead and just come back out. If you want to go on the record, you can. If you don't need to, then we're great. The defaults will be taken at 2:00. Steve, were you listening too?
I am listening. Yep.
Okay, so she'll put you in your breakout room too. Okay.
Thank you. Thank you.
So.
So the
Hi,
only
Darius, iPhone. Are you
attorney-
Raven Whitehead?
Yes.
Okay, let me rename you.
Okay.
Sandy, now the attorney on this case, remember what he said, that they came to an agreement, I thought. So what do we need
Was
to
that
do?
Robert Novak? He's in.
No,
Birch
Mr.
Run.
Rabbits.
I thought it was Robert Novak.
It
Yeah,
is
it
Novak.
is
It
Robert.
is.
Yeah. So go ahead and put her in there and just let her, Miss Whitehead, she's going to put you in the breakout room with the attorney. If you guys have a consent judgment, just come back out. Can they come back out, Heather?
Yeah, and then what do we do?
And then we'll just go from there. We'll ask them if they want it on the record. If they do, then we'll let judge know. If they don't, then they'll be all set.
Okay.
So basically what you're doing is you're just putting them in there. If they have a consent judgment and they don't want to go on the record, they're free to go. If they want to go on the record, then we just have to tell them that they're going to have to wait for the judge to get here. And then you just, I don't know if he said to text him, call him, whatever, and then just let him know.
Just let him know as soon as he gets them.
Yeah, you can. You can work that out with him. I think he was okay with, if we got one, just call him and he'd come in or something.
Okay.
I think he was okay with that.
So that's when people tell me that they want to put it on the record.
Yeah.
Okay. Brandy, I'm putting you in the breakout room with the attorney.
Okay.
Oh.
Which one was she here for?
Brandy was here for Steve Robinson.
Okay.
Raven, did you not go in the breakout room?
Yes, I went in, but he told me to get out and come back in because I couldn't hear him.
Oh, okay. Then let's try that again. Can you hit join again? Is that an option?
No, it just says leave at the top.
Nope, you don't want to leave. Okay, I'm going to do this. See, and I don't have an option to put them back in the main room.
See, I think that's maybe why we do it, because they can go back and forth.
And she was Rabbits.
Yeah, sorry, I renamed him Robert Novak, so that's why I said that.
Are you guys good on this case? What's going on?
We have a consent judgment as to her, and then it'll be a default as to the other defendant on the case.
So we have to wait till 2:00 for a default as to the other person.
Okay.
So we really can't take it until then, but is she going to sign it or? did
She
agree
gave
to
me
let you-
permission to sign.
Stacy, did you give her permission to sign your name?
Yes, ma'am.
Okay, just checking.
Not a
So yeah,
problem.
so she can go ahead and go.
Okay.
And then at 2:00, we'll take your defaults in that consent judgment.
Okay, very good. Sounds good. I will pop back into the breakout room then. And then do we have any, I
Do you
think that
have
was
that
the only,
option? Do you have that option, Jen?
Yep.
Oh, okay.
What does it say?
Pop back to my breakout room. What's that?
What does it say?
So if I, the bottom of my screen, I can hit a tab that says breakout rooms. And then once I click that, it gives me the prompt, you've been assigned to breakout room Levine, and it'll let me just go back to that breakout room.
Thank
Okay,
you.
thank you.
I can go.
Stacy?
Do we
Yes.
have,
Stacy, you're all set.
Okay, thank you.
and then do we have anyone from any of the other properties here yet?
You do. I think you have Todd Barker. I'm going to bring him in for you.
This is Raven Whitehead. I still can't hear. We can't hear each other.
Okay, Mr. Ravitz, is it, or Mr. Novak, is it your phone or hers?
I just logged off and logged back on. Now I can hear you guys. Maybe you can put us into a breakout room now. Maybe there was an issue.
Yep, I would. Raven, will you look at the bottom of your screen and see if it tells you that you can join the breakout room? Is there a spot that says breakout room?
No.
Hey, Rob.
Yeah.
Your client here.
Do you want to just talk with her here, Mr. Novak? Or are you
I
good
put
with
her
that?
in a break. I put her somewhere and
got
I'm
her,
going
okay.
to bring her back. But what, Mr. Ravitz? Sorry, Novak.
Yeah, we can talk right now, Miss.
Wait a minute, let me bring her back in.
And he's gone.
Yeah. All right. Todd Barker is going back with, what was her name? With Levine.
Yeah, Levine.
And then Jessica Harris. I remember her earlier. Oh, she's for them also, so I'll give them a few minutes.
Okay, yeah.
All right, you guys are back out.
We have an agreement.
Okay, do you need to put it on the record?
Not really. Miss Whitehead, are you there?
Yes.
What we've agreed to, Madam Clerk, is that this is a termination of tenancy. Miss Whitehead agrees to vacate and surrender possession to the property on or before October 31st. And what we're going to do is a consent order of dismissal.
Okay. Are you
And Ms.
good with that,
Whitehead?
Miss Whitehead?
Yes.
And I have permission to sign your name to this?
Yes.
And I told you about the 3-day appeal period?
Yes.
And Madam Clerk, if you can give me the fax number or email, and I'll get this over to you.
I can chat you the email.
All right, beautiful. Thank you, Miss Whitehead.
Thank you.
Have a good day. Bye-bye.
Bye-bye.
Oops, I lost the whole meeting. There we go.
See how easy that was?
Isn't it nice though sometimes when you're not the only one that it happens to?
Yes, yes. You know what? We were communicating by sign language there for a couple of minutes.
I was wondering because she said he told me I couldn't hear him, but he told me to come back out. I'm like, well.
All right, Miss District Court -mi.org. All right, give me a few minutes. Let me prepare this. I'll send it over.
All right, thank you.
Thanks so much. Have a good day. Bye-bye.
You too. Bye-bye.
All right, Mr. Landau, I'm going to put you in a breakout room waiting for the other parties. Defaults and consent judgments that need to be put on the record will be taken at 2. Ones that do not need to be taken on the record, if you have permission to sign, then you can just have the other parties leave.
You're muted, Mr. Landau.
That's fine. I put him in the room.
Okay.
He was shaking his head. Was this all the right stuff, Sandy?
Yep. Yeah. The only thing is that it was all, I mean, that was perfect actually. So I just, when they want to go on when they don't want to go on the record and they have a consent judgment, I just like to hear that the defendant says it's okay to sign their name. I don't know why. I don't know if we have to or not.
Okay.
And are you keeping track of who's here?
I have been, yes.
Okay, because that's the biggest part. So like when they say they have a consent judge or default judgment, but I see you've checked someone off that was here, it should be a consent, then that's, then I have to call the attorney and have him fix that. So that's really the biggest thing is I need to know who appeared.
Well, so like Nestor, he is going to be a default, right?
Yep.
And then Stacy was a consent.
If they're here, I usually put a check mark by them. If they didn't appear, I put a slash by their name.
Okay.
I don't know if that helps. That would help me.
It could, yes, yes. Thank you.
There was one that was dismissed. It was 214213. So you're not going to look for Rayanne Fox or Roy Fox.
Oh, thank you. Dismissed.
So then what I do normally too is at 2:00, I will lock the meeting
Okay.
because the judge gives them a half hour. And Heather, can I just tell you something else?
Sure.
So like if Levine has a bunch of cases, so what I usually do is I have him go over them and say, okay, give me your defaults. And then the ones that haven't appeared are going to be defaults. So I just mark them down to make sure that he's got all the same ones that I have.
Oh, okay.
And then if, you can say, okay, consent judgment and have him do that before I let him go. That way I don't have to call him back and tell him, hey, you missed one.
Okay.
The ones like Robert Novak, he's already done, so you don't have to worry about him.
So the ones that only have one, when they're done, they're done. Okay.
Yep. Holler if you need me. I'm going to mute. I see my microphone's picking up my paper shuffling.
Oh, okay. Yeah. Thank you.
Yep.
Hi, Mr. Robinson. Are you guys all set? You're muted.
Yeah. Oh, God. The bane of my existence. The mute button. Hey, are we going on the, how are we doing this now? Because we're with Judge Oakley and
Well, we need to know what you plan on doing.
we got a consent.
You need to go
Sandy?
on the record?
Oh, who's that?
Sandy.
It's me, Sandy.
Yeah, Sandy, what we can do is, if it's up to you, she's gonna come up, she's just gonna pay October and then the other 300 by the end of next Friday, but I don't want to enter a judgment against her. So if we can just adjourn it 2 weeks.
Heather, do you have a date? Can they adjourn it?
2 weeks. We've been giving, I mean, it depends, like, is this just a quick meeting?
Oh,
October
yeah,
27th.
yeah.
I mean, would it be something that, because earlier, Sandy, we were doing November 2nd in the afternoon.
Yeah, he did a couple there, but he said he wasn't going to have time. So that would be, or we could go out. How far do you need? How far would be agreeable? We have like November 23rd, his actual civil docket. Is that too far?
Yeah, I don't want to go, I want to do this. I mean, normally I would ask for a consent, just a consent judgment today.
Yeah.
But I don't want her to have a judgment. So I'm just going to give her the benefit of the doubt. And
that
so,
she's going to move? Or
no,
pay?
she's not going to move. She's going to pay. Because she's already shown me the money order for October. So all we're talking about is 300 bucks.
Okay. So if you want to go ahead and give him the second at 2, what time did he say, Heather?
I'm sorry, are you talking about on November 2nd also?
Yeah.
Yeah, do 2:45.
2:45? Okay. Okay.
Steve,
Okay, so-
are you able to go back in there and let Miss Clark know that she can leave if you guys are all set? Or are you going back in there to talk to her?
Me?
Yeah.
Yeah, talking to you.
I wasn't planning on it, but
Oh, okay. I can have Sandy go in there and talk to her.
okay.
Okay. Bye, Steve.
Thanks, Heather. Thanks, Sandy.
Hey, Heather,
Yes.
you want me to go in where you have to give me send me in there?
Right. But so do you usually have a thing where you can bring them into the main breakout room?
Yeah.
See, I don't have that option.
See, maybe that's the way we set it up. Because I usually can bring them right back in to the main session.
All right, let me throw you in number 7.
Okay.
Or you know what, let me, Sandy, so that you can speak to Miss Wilburn and see what's going on with this case.
Okay.
I'll go tell Miss Brandy to
okay.
come out. Thank you.
Hi, Miss Wilburn, you're muted.
We have a consent judgment on this one. Unless Mr. Barker needs to speak to the judge, I think we're good on this one. The only question he had is if it would be possible, I'm going to submit this as soon as we're done to the civil email. He was wondering if there was a way once the judge signs it to get a copy, maybe by email, or if he could come by the court and pick it up.
Sure, you can come by the court if you'd like to. I could try to email it. I can't promise that I'll remember though. You know, I'm getting old and
sure.
So if you give me your email, Mr. Barker, I can try.
Okay. It would be Todd Barker 2007 @gmail.com.
So it's TODD.
Yep. BARKER 2007 @gmail.
Okay. I will try as soon as the judge signs it and get it to you. If you don't have it by tomorrow, you can give us a call and either come up and pick it up or remind me.
Okay, I can come up and pick it up. That's not an issue. I just didn't want to drive all the way up there before the judge had signed it. That's all.
Yep. He's normally really good about signing them. So he'll probably, as long as I get it today, I'll get it up to him and I'll have it by tomorrow.
Okay.
And you'll definitely have it from us today. So
Okay.
Mr. Barker, since you gave me your consent, you should be free to go.
All right. Thank you very much.
You're welcome. You have a good day.
You too.
All right, I'm gonna pop back if there's anyone else to be put in our breakout room.
There is. I'm getting ready to put Jessica Harris with you.
Perfect, thank you.
Thank you. Ms. Harris, I'm going to put you in with the attorney.
Okay, no problem.
So Brandy?
Yes.
Okay, so Mr. Robinson is gonna, you're going to go ahead and pay the rest of the money to him. We have this set for a hearing for November 2nd at 2:45 with the same Zoom ID number.
Another?
Unless you pay. If you pay, then he'll send in a dismissal.
Oh, okay. Yeah.
Okay.
Like I told him. Okay. That's fine.
Okay, yeah, so if you pay, then he'll send in the dismissal, but if you don't pay, then you'll have to be at that hearing, okay? And I will send out a new notice. So if you get that notice in the
Okay.
mail and you paid, you don't worry about it, but.
Okay.
Okay?
Okay.
So you're all set then for today.
Thank you.
You're welcome. You have a good day.
Thanks. Bye-bye.
Bye-bye.
All right, let's leave this.
Okay, so Heather, I see Terry Butcher. There's two parties on that, James and Terry. What I would do is I would bring in Terry and ask her if James is going to be here.
Which case? Oh, it's for
the very first one.
Dakota.
Yeah.
Okay.
Yeah.
Terry, is James going to be here with you?
No, I'm sorry. He's working right now.
All right, I'm going to put you in the breakout room with the attorney, okay?
Okay.
Hello.
Yes, Sandy, for Miss Harris, she has applied for Sarah funding.
Okay.
Are we able to just get a new date for her?
What we'll do is we'll stay the case since she's applied,
Okay.
and we'll send you out a letter that says, if in 45 days, if you guys haven't received anything, you'll just send us that letter and we'll reset it for a hearing. Okay.
Perfect. Okay, thanks so much. So Miss Harris, you're all
welcome.
set for today.
Okay, thank you.
Yep.
Have a good one.
Sorry, Heather, I should have told you about that one too. I forgot.
Oh, about the Sarahs?
Yeah, if they say they have applied for Sarah, then we stay the case 45 days and we'll send a letter to the plaintiff's attorney.
Okay.
All right, and then do we have anyone else check in?
Not right now.
Okay.
Got 5 more minutes for them.
Okay, I'll pop back to the room for the last 5 minutes then.
Thank you.
Thanks.
So Heather, unless Dakota Hoffman has his people go in, there's nobody that's going to go in, right?
Correct. That's what it sounds like. Because that's the only one left.
Yeah, the other ones are going to be defaults.
Yep.
Unless somebody appears, but. So cool.
But they got 3 minutes and I'm going to lock them out.
Yep.
I will say on my normal stuff, I'm not into doing that lockout, but on this, I'll lock them out.
It's just because you'll have the people that'll come in like 15, 20 minutes later and say, I and it's like, no, come on, you had your
Exactly.
notice,
Thank you. Yeah. Sandy, should I close the breakout rooms and bring everybody in?
Yep, it's 2:00.
But what about Butcher? They're still talking.
You can leave them in there and bring like,
I can't undo anybody.
No?
No, because my breakout room won't let me.
Well, hopefully they'll come back out, realize what time it is, or they may be in there all night.
Yeah, because I can close all of them, but it'll mess up theirs. I can just throw them back in.
So do you know how to? Yeah, you can do that if you want.
Mr. Applebaum, if you didn't have enough time, wait a minute, where are they at?
Can I actually be placed back in there with Ms. Butcher?
Yes.
Thank you.
Thank you.
Wait a minute, where did she go?
Right here.
Do you see her there, Heather?
It won't, wait a minute. So he didn't go anywhere either.
Did you reopen the breakout rooms?
No, because then it throws everybody back in. It should move them now. And it's not. All right. Sorry, Judge.
No problem.
Okay.
All right, what's first, Heather?
Sandy. Because
we can go ahead with John and Kathy. I believe they just have a default. I think they're all defaults, Judge. So
how about a file name?
yeah.
MIMG versus Cutius, CUTIUS.
Thanks, Heather.
Thank you.
Yes.
Counsel, your appearance on Ming XXX Gateway.
Thank you, Your Honor. John Burnkrant for the plaintiff landlord, Gateway.
And Cutius did not appear.
I have no knowledge that she's there. She did not appear in the breakout room.
No, Judge, she did not.
All right. What's your pleasure, Mr. Burnkrant?
We would request the court for the entry of a default judgment for possession. The rent owing is $2,061. The costs are $167. With the writ to issue, if that's not paid or the tenant's not vacated within 10 days of today, I did submit within the last 10 minutes or so as a proposed judgment for entry to the civil email address.
All right, they'll put it in my pile and I'll sign it.
Okay,
That it?
thank you very much, Your
One
Honor.
file for you?
That's the only file I have.
Have a good one.
Thank you, Your Honor. You too.
Next judge is going to be Bell Villa versus Bailey and Bell Villa versus Ahern. And it's Mr. Landau. Can you unmute yourself, Mr. Landau?
Ready? Good afternoon, Your Honor.
Good afternoon, counsel. Your appearance for Bell Villa.
Mark Lando on behalf of the plaintiff.
And we haven't seen either one of these defendants, correct?
That is correct.
All right, what's your pleasure?
We are seeking a default judgment against both tenants. Do you want me to put the particulars of the dollar amounts for each tenant?
Sure, put them on the record.
Okay, with respect to Rita Bailey, she owes $1,295.68 in rent, $155 costs. Total is $1,450.68. With respect to Belleville Meadows versus Miranda Ahern, she owes $1,890 in rent, $155 in costs. Total is $2,045.
And you'll submit?
We will submit the default judgments to your clerk momentarily.
All right, you submit, I'll sign. Have a nice day.
Judge, have a wonderful day.
Thank you.
Next one, Judges Park Estates versus
Thank you.
Shavara.
All right, appearances on Park Estates.
Good afternoon, Your Honor. Jen Wilburn for the plaintiff, Park Estates.
Thank you. And Shavara did not appear, correct?
Nestor did not appear, so we are seeking a default as to him. This is just a possession case. This is not over money. Stacy did appear and gave me her permission to sign.
Awesome. Submit the judgment for my signature then.
Very good. Thank you, Your Honor.
You're welcome.
Next is West Village versus Jones.
Counsel, you parents for West Village.
Oh, you got rid of her, Judge. She's on all of these.
Oh, okay. She'll call back. Who else we got?
Nothing. Well, Sandy, did you want to tell the judge what happened with Mr. Robinson's case? It's L. Nimery versus Clark.
On that one, Judge, Steve wanted to adjourn it out to 11/2 because Mrs. Clark is going to pay. If she doesn't pay by 11/2, then they'll come back on. Otherwise, he'll submit a dismissal.
All right, and if he comes back on, just spin him off. But one of the other judges handle it next time around.
Okay. Thank you.
Yep. What about Birch Run or Maple Leaf?
Those are all with Jen Wilburn, the attorney.
Okay.
You have to unlock your meeting, Heather.
Oh.
Counsel, you ready on Redford East?
I am, Your Honor.
Your appearance.
Dakota Hoffman for plaintiffs, Your Honor, P84527.
Thank you. Ms. Butcher, you can hear me all right?
I'm sorry?
You can hear me okay?
Yes.
All right, counsel, what do we got?
Your Honor, this is a non-payment of rent case. Ms. Butcher has appeared. However, she's not living in the property anymore. The person who's actually living in the property is Mr. Butcher. He has not appeared to the first hearing or this hearing. What we'd ask for is a default judgment against Mr. Butcher, but we'd like to dismiss Ms. Butcher from the case.
I'm assuming that's okay with you, Ms. Butcher?
Yeah, that's fine with me.
All right, dismissal as to Terry.
If I may make one comment,
Go ahead.
Mr. Butcher isn't here today because he's working and I'm actually his boss and I wouldn't give him the day off.
That doesn't save him from a default judgment.
I understand.
Counsel, submit your paperwork.
Okay, thank you, Your Honor. 10 days, okay, for the default?
Yes.
Okay,
Yep.
Thank you, Your Honor.
Have a good day.
You too.
Counsel, my apologies. I kicked you out before they told me you had the rest of the docket.
No problem, Your Honor.
Your appearance on behalf of West Village.
Jen Wilburn for the plaintiff, West Village.
All right, so you have not seen defendants Fox, Howell, Lindsay, Rappaport, Rhodes, Jones, or Jones, correct?
That's correct, Your Honor.
All right. Submit default judgments on those files. You can do that electronically.
Yes, I can, Your Honor. I will get those in this afternoon.
Thank you. And
Judge,
you're on Birch Run as well?
On which one, I'm sorry?
Are you on Birch Run as well? Birch Run Co-op.
I have Maple Leaf South left and Metro Commons left.
All right. So Maple Leaf Gardens, your appearance.
Jen Wilburn for the plaintiff.
And you have not had any contact today with Barker or Clemens, correct?
Mr. Barker was here and we entered into a consent judgment. He gave me his permission to sign. I have not had contact with Stephen Clemens.
All right. So you'll submit a default on Clemens.
Yes, I will, Your Honor.
Thank you. And what else you got?
Metro Commons.
All right. Have you had any contact today with Anderson, Brown, Burke, or Harris?
Ms. Harris was here. She has applied for SARA funding, so a 45-day stay will be put in place. I have not had any contact with the other defendants.
All right. I didn't catch the name. Miss Harris, is that it?
That's
She was
correct,
here?
Your Honor. Yes.
All right. What are we doing for Miss Harris?
She has applied for SARA, so just the SARA stay needs to be put in place.
You keep cutting out Sarah, and then that's all I hear.
She has applied for SARA funding, so if we could just get that 45-day SARA stay.
All right. And then on the other three files, I think it is, you'll submit default judgment.
Yes, Your Honor.
Thank you very much.
Thanks, Your Honor. Have a good afternoon.
You as well.
Thank you.
Sandy, what's going on with Birch Run?
Let me find that one, Judge.
That one, they came to an agreement.
Okay, yeah, that's Robert Novak. He's going to send in a consent judgment.
Thank you. All right, shutting down then?
Yep.